Lordship has already, it's gone through all the law.
Does he have a written?
I
don't know.
I've sent my propositions, they're already hopefully before your lordships.
Under what head? What head?
We also have printed.
No, Mister, we don't have that. If you can have some, your junior,
We've
email it to the court master, we'll immediately get it.
We've circulated it, but
No,
we'll give you the print.
Nothing. Not on the,
It's been.
just sent.
I've got physical copies also.
No, let's do it on the electronic form,
Yeah.
all of us.
All right. Give it to them.
Mr. Sibbal, what happened to your iPad?
I have it. I have it, and I'm going to honor, my commitment to your lordship.
We had to do,
In this field, at least,
to do it in other courts too, besides
No,
court
it's a
one.
temporary measure.
Is it a proverbial elephant's, task?
No, in fact, I've been assiduously, trying to learn on a daily basis, and I've managed, quite well. I'll start off by saying, that I was very worried, at the outset of the hearing, when on the other side it was said that Parliament is not going to do anything about it. We don't expect Parliament to recognize this particular right. And therefore, we urge your lordships to give us a declaration. Because I'm afraid that that's a very dangerous proposition.
Sorry, will you repeat yourself, Mr. Sibbal?
I'm sorry?
Will you repeat yourself?
It was said, at the outset, that we don't expect Parliament to move forward. We don't expect Parliament to pass such a law. And therefore, your lordship should do it. And I said, that's a very dangerous route to take. Any law of this nature, which is pursuant to a tectonic shift, as I said, in societal values, requires public discourse, which includes discourse in Parliament. It includes discourse outside Parliament, within the assemblies, outside society. And therefore, a declaration by itself on the premise that Parliament is not likely to pass a law, is, as I said, a wrong step forward. But let me go to the heart of the matter. When your lordships were dealing with NALSA, you got it?
What's happening in Kote?
16. 18.
It's a dangerous route to take, because a declaration by your lordships will close the debate in Parliament. There will be no scope of debate once you declare. One, that it's a fundamental right. Two, it has to be recognized. That's, with the greatest respect, something that your lordship should be cautious about. Nothing more than that.
Parliament can overrule a declaration also, no?
Sorry?
Parliament can overrule a declaration.
No, but your lordship knows that once your lordships have declared, Parliament cannot overrule it. I hope, Mullah, that stage has not come for Parliament to overrule what your lordships decide. I'll be on the other side when that happens, Mullah. But Mullah, let's Mullah, go to the heart of the matter. In Nalsa, your lordships decided sexual identity. Sorry. In Nalsa, Mullah, your lordships decided,
Nalsa, you say.
yes, sexual identity, nothing more than that, of transgenders. In the privacy judgment, your lordships decided upon the contours of privacy, both in the private space and the public space.
Can you say that again? Nalsa was a declaration.
Yes,
Identity.
there was a declaration.
Identity.
Yes, exactly. On sexual identity. In privacy, you decided on the space for privacy, both the private space and the public space. That even the public privacy must be protected. In Navtej, you decided on decriminalization.
So conceptually, you say the third one is slightly different
Yes,
because it is only a decriminalization, which is statutory.
correct. What you are today deciding are two things: sexual unions and recognition by the state of sexual unions. That's the issue, Malaj. None of these issues, Malaj, were looked upon, decided, contemplated, thought through in either of the three judgments. So any Malaj reference is made in the context of those three particular issues decided in those three can't Malaj be taken as concepts which must be a fortiori accepted by your lordships. Right? So first you have to decide, are they a separate sexual identity? And in the ultimate analysis, Malaj, my answer will be yes. The next step, should they be recognized by the state? The answer is not through a declaration. This broadly, Malaj, is going to be my submission before your lordships. And Malaj, I respectfully, Malaj.
Just a little clarification. Your first question was, are they a separate sexual identity? And you said yes.
Yes.
Second, should they be recognized by the state? And your answer was not through a declaration.
No, their sexual identity, yes.
Yes.
right? Once your lordship recognizes it, then the question arises, sexual identity as a sexual union.
No, I just had a little clarification because, I'm just
Yes.
taking the submission down. Second point was, should they be recognized by the state?
Yes,
To which you said, not through a declaration.
not through a declaration.
Now, when you say, should
Not
they,
through a legislation, I said.
not through?
A legislate. No,
No, no,
they can only be done through a
Yes,
legislation.
yes, that's right. I took it down.
So
like
you're-
that.
You're basically, you're advocating a Scalia-Roberts approach.
Yes,
Right. Now,
Absolutely.
when you said, Mr. Sibbal, when you said, should they be recognized? That's what my question.
that sexual identity,
The sexual
which is
union.
separate from sexual union.
Sexual union.
Union.
Not sexual identity.
No, no, identity, Malad, I want your lordship to give that declaration.
So that word, they, will just modulate it to
Yes.
the sexual union.
Union, yes. Now, the question then arises, is this sexual union a marriage? That's what we've been debating, Malad, for the last an hour or so.
It was the third?
Is this sexual union akin to a marriage? If it is akin to a marriage, is it founded in any provision of the Constitution? Next question. And then the third, for it to result in certain rights, it can only be done through recognition by the state, through legislation. There can't be a declaration to that effect. Well, it's when your lordships ask the question.
Constitutional perspective, the constitutional lexicon,
Yes,
when you say can't,
yes,
the can't has to also fit into some constitutionally recognized prohibition.
yes. Which
You
is,
would
Malad,
say
that
that-
it's a regulatory exercise of rights ultimately have to be regulated.
No, that's-
Regulation can
that's
only be
regu-
done through law.
No, no, that's right.
Yes,
That's part of regulation. We are on a more fundamental path.
yes,
Declaration.
yes,
We have now evolved to the extent of understanding what are constitutionally manageable standards,
yes.
existence of it, non-existence of it, matters which are not to be gone into the court by the court, etc. Where would you locate that? When you say a prohibition is prohibited,
Well,
The
I tell
declaration
you,
is prohibited.
moment your lordships decide that this union is a marriage, in what context will you decide that, Malad? Ultimately, what is a marriage? The marriage is only a union.
Forget the issue of whether the court should declare this to be a marriage.
Yes,
We are now on the core issue as whether the court can issue a declaration.
that it's a marriage.
No,
that it's a union.
That the court can issue a declaration.
A declaration qua what, Malad? That it's a sexual union. That's all, Malad. It can't be doing anything
Yes,
more
you're
than that.
right. See, there is no declaration in vacuum or vacuum.
No, Malad, there can be,
Of
Malad.
course, you're right, but see that the court has in its repertoire a right to declare right from 1960, Justice Subbarao, I think that Kochuni onwards
Yes.
is there. Question is, what is that declaration we have to issue? Will it be marriage or not marriage or something?
No, that's the question that, Malad, I'll try and address your lordships on, but that's the really core issue.
So the court has in the past issued declarations, for instance, declarations which postulate that the implementation of the declaration requires legislation being enacted by Parliament.
Yes,
The right to a clean environment, for instance.
yes,
The implementation is ultimately for Parliament to
Health.
say the health, education, which eventually the right to primary education found expression in the Right to Education Act.
yes,
Or
absolutely.
the
It became
right
a
to
constitutional right thanks to a certain declaration.
Or the
I
right
agree
to
entirely.
food, which eventually resulted in the enactment of a legislation.
I'm with you on that, Malad.
Therefore, at its core, is a constitutional precept to say that the court cannot issue a declaration would not be correct. Equally, we take your point that don't go into an area where you declare a right to marry, because that's Mr.
That
Dwivedi
was
has
the
argued,
intent. That was the
solicitor
intent.
has
That was the intent. Malad, let's first of all define what marriage is before we move forward. And Malad, my
Yes,
Lord
we'd like
Justice
to
Bhatt, your
study
lordships,
assistance
Malad,
on that.
let's look into that. Ultimately, what is marriage? Forget about the law of 1955. Forget all that. Marriage ultimately is a union. It's a union of two persons. It's a sociological phenomenon which deals thus far with heterosexuality. Thus far. It's a union, Malad. Even if the 1955 Act were not there, Malad, it's recognized within and without as marriage. When I say within, by two people, pay that union, and without by society. So there are two elements to it. Recognition within, recognition without.
Could you just elaborate on that a little bit?
Well, let's, for example, as I said, in the absence of a law, this union of two people with all the sacramental vows is accepted by a large majority of society for thousands of years.
That's the recognition without.
Yes, that's the recognition without, right? And that's essential. That's essential.
So the recognition without, according to you, then is the social recognition.
Is the social recognition. Thus far, it applied to only heterosexual couples. But it's still a marriage. But a marriage which is gained acceptability over centuries. The union between sexual union between sexually people who are homosexuals or whatever is still a union. You can't say it's not a union. They have a sexual identity which is separate. It's involuntary.
Involuntary?
In the sense, well, it's involuntary in the sense that these are their sexual.
It's not a matter of choice.
Yes.
That's what they call as ascriptive.
Yes.
See, in that
They have no
sense,
choice in the matter. That's how it is physically.
it could be said of both in that sense.
Sorry.
Could be said of both sets.
Yes, of course.
But that apart, it is voluntary in the sense that they choose.
Of course. I don't mean.
Just like in this.
The manifestation is involuntary. Otherwise, it's of course a voluntary union. I don't mean that, Melissa. It's consensual. It's voluntary.
Your sexual orientation may not necessarily lead you to a union.
That's right. It may not. It may not. That's what I'm saying, Melissa. Therefore, we are not talking about sexual orientation here, which is what I was started with. We're talking about a sexual union, and we are trying to give that a name. That's what we're trying to do, Melissa. That's why you'll also ask the question, what's a marriage? Right. Right? You give it a name. Now, they may consider that this is my marriage. Who can stop anybody? How can anybody stop them from considering that this is a marriage? Nobody can stop them. There are two people who decide that they want to live together. They live together for 10 years, 15 years. They say, I'm married to him. The moment you say now, without, you must recognize it, comes the problem. You may find it in 21, you may find it in 14, you may find it anywhere else. You may not find it in the Constitution at all. According to me, it's part of your right to be and to live as you please without interference from the outside world. It's part of privacy.
And according to the recognition without, if the court were to be invited to give a declaration of recognition without,
yes,
that would amount to an imposition on others.
That's the point. That's the point. That's the core issue before your Lordship. That's really the core issue.
If I could just translate it in a very colorfully, maybe not so. It's like drawing a blank.
Yeah.
It's like firing a blank. So which means that you allow it, but outside, without, there is no acceptance, there is no.
That's really the heart of the problem.
The counterpoint to that is there may or may not be, but that lends us dignity in our own eyes. That lends us acceptance among our society.
Yes.
And the society without, to that extent, limited extent, among our parents, among those people who are willing to accept us. That is a point you may have to
True,
deal.
true, Malad. That's certainly an issue that your lordships will have to consider. But the point that I'm making is, Malad, at the moment, what are they asking? They say under the Special Marriage Act, the rights given to heterosexual couples should be given to us. That's what they're asking. That's their ask, Malad. Nothing short of that. And that's what your lordships is considering.
Mr. Sibbal, when we opened the discourse, we confined it, of course, we confined them to the Special Marriage Act with the idea in which we still maintain that we are excluding the whole gamut of personal law
Yes.
from the debate.
Yes.
But we're not really confined only to the contours of the Special Marriage Act in deciding the broader constitution.
That I know, 14, I'm going to come to that, Malad. That's the other issue. Is it discrimination? That's
So when we locate the nature of marriage, the institution of the marriage, we're not really then confined only to the Special
I agree,
Marriage Act
Malad.
or its
Therefore,
statutory contours.
I agree entirely. Therefore, your lordships are also considering whether there's discrimination under 14 or not. And therefore, can you then say that this is discriminatory? But where does it go from there? That's the next question. If you find it discriminatory, where do you go from there? That's an even more difficult task, Malad. First, to find that it's discriminatory, that itself is an issue, Malad. Because we are talking about separate sexual identities and unions.
That will continue after
Yes,
that.
we'll continue.
Mr. Sibbal, roughly how long will you take just to have a...
I won't take much time, Malaz. I'm not going to trouble your lordship with all the judgments. I'm just taking the dialogue forward, Malaz, so that your lordship knows.
Because now we've seen the judgments. We like some assistance at the intellectual level now, and
Yes.
we just forget the judgments unless there's something somebody else.
That's correct. That's correct.
Yes, Mr.
So we were talking about acceptance, Malaz, just before the break. Now, acceptance is also at 3 levels. The first is the acceptance by the two individuals themselves, right? That's the seminal level. Then is acceptance by the family. In many cases, there may be acceptance. In some cases, there may not be acceptance or vice versa. I don't know. I don't have the data.
And by society.
And then, Malad, it's a concentric circles which has 3 Malads, like public order, your lordship
Yes,
remember.
just as that Lohiya.
So there are 3 concentric circles
Freedom
here.
of speech.
Now, who is to investigate that? This is the problem, Malad. This is the issue. Who is to look at that? And there we need the aid, Malads, of all kinds of data, opinions, conversations, discourses, debates. If you look at the quintessential form of marriage, which is heterosexual couples, why has it stood the test of time, Malad? Because at all 3 levels, there is acceptability. Now, you may call it by any name. In the Hindu custom, if you go around the fire, at the end of it, it's complete. In Islam, it's different. In Parsis, it's different. So society recognizes that union and gives it a name. You don't need the constitution for it, quite frankly, Malad. It is one of those inalienable rights, the right to a union. That inalienable right inheres in them also. That right to that union, Malad. You may call it by whatever name. But if you want to, let's equate it to a heterosexual union, you need all the elements which go into the heterosexual union being recognized. And if you look at the institution of marriage as an organic evolution, of custom and usage, you will realize that its roots in here, in societal acceptance, along with concepts of societal standards and morality. Now, that concept of morality may change, societal standards may change as they are changing. Both societal standards and morality is changing. But it inheres in that. Why can't, Mullahs, you marry your son's widow? It's nothing to do with blood relationship. It's something to do with standards, which the state recognizes as state interest.
Some the state imposes,
Yeah, some state imposes.
others the state recognizes because it's inherent to order.
Correct. I agree entirely. Entirely. Well, supposing I were to say it's a matter of choice that I want to have, three of us want to live together and we want to marry. Well, nothing wrong with it. I mean, conceptually, there's nothing wrong with it. Where will you place it? Will you call it a marriage? And well, Justice Roberts asked this question of a pluralistic relationship to counsel who were arguing. And he said there was no answer. He said that time has not yet come. So choice by itself is a slippery slope because it is elastic.
Say that again. Three people want to live together.
That's right. It is elastic. Choice is elastic, Malas.
No, three, there are societies.
Yes, they
Maybe
do.
minuscule, but there are polyandrous.
Of course.
I mean, that perhaps is not there.
That's
but
correct.
it is there in our society.
No, I agree, but therefore, does it get recognition in the form of law? The question is that, Malas, that's the question before your lordships. I am not being moralistic about it.
No, without being moralistic,
Yes,
we
I'm not.
do recognize
It's
that.
the reality. It's the reality. It's the reality. So when you base it on choice, it becomes somewhat difficult. And if you base it on equality, it's even more difficult. Now, let me assume that Parliament were to pass a law tomorrow in respect of same-sex unions. What if that law is challenged saying that you are treating equals unequally? Will you strike it down? You won't. That's the answer to the question. 14 requires equals being treated equally. Equal work for equal pay for equal work. You can't equate a practice that has the sanction of society for hundreds and thousands of years with
This question. Still be upheld.
You can't essentially equate these two unions, Malaj, in one class. You can't essentially do that. Therefore, this debate of procreation, love, trust, all that, Malaj, is really beside the point. Just as you can't deal with transgenders in the same class as same-sex. Can't deal with that as same class as heterosexuals. So you'll have to have separate regimes. To what extent will you recognize? To what extent you won't recognize? Whether you will give them some civil rights. But I think the starting point of that is recognition of their sexuality, of their sexual identity. It is my request that this court declares that. They have a separate sexual identity. What will happen? What will happen is what happened in Kedan.
Then, Mr. Sibbal, if we declare their sexual identity, as you quite justifiably you are saying that we must, then the court may also then have to contemplate what are the rights which are not concomitant to
I'm
the
coming
declaration
to,
of
Malaz, I have, in fact, all this is in my paper, Malaz. I'm not troubling your lordship.
Just to play the devil's advocate.
Sorry?
Extreme, just to play the other complete extreme side. Supposing you declare that there is a sexual identity, as you saying,
Yes.
as you are saying that you declare a sexual identity, and supposing Parliament comes up with a DOMA.
Yes.
A DOMA.
Yes. You strike it
That's
down.
DOMA.
You'll strike it down.
Why?
I think so.
You have a sexual identity, but you will not enter into marriage.
I come back to your lordships and have it struck down. But Malaz, I want to say something else to your lordships. That what will happen if you do that? Malaz, I am here, Malaz, at the center. I am to assist your lordships, Malaz. What will happen is Gaidan will happen if you do that. In your rent relationships, Malaz, you will automatically get the right for the spouse to. What happened in Obergefell was that under the US, gay people were not entitled to military service. They were not entitled to government service. They were discriminated against qua immigration. None of this is happening to our people here. Apart from immigration. They can enter government service. Nobody asks them a question. They can go to any space they want to go. So we are far more liberal in that sense. The US court was dealing with essentially an illiberal environment.
We are also dealing with a situation where an individual in her or his capacity is entitled to adopt a child, but merely by dint of the fact that you are in a same-sex relationship, that right to adopt even as a single individual is denied.
I agree, but there are people have adopted, Mother, that's not an issue. People have adopted children, even in these relations, even today. There's no issue at all. There are adoptions today, mothers, that we know of by same-sex couples.
Mr. Sibbal, may I say something?
Yes, sorry.
See, when those adoptions are taking place, they are proceeding on a declaration that one of them is adopting. So it's not a declaration.
I agree.
Relationship.
That's true.
And that's in that context, this one of the circulars which the Chief Justice had flagged had come into being and would be addressed by the Additional Solicitor General while appearing for the adoption group. So
yes, your lordship is right.
What the circular does is, the circular says that though you are entitled to adopt as a single person, merely by virtue of the fact that two of you are cohabiting together, we'll deny you that.
That's where you incrementally need to expand. This is precisely my point.
Absolutely. That's the point we also
That's the point, I am also making. That you should not make a declaration at this stage, allow this to incrementally expand these rights once you give that identity. That's very important, Malaj. Most of these cases, Malaj, Ontario versus MNH also deals with the same situation.
But the moment you recognize sexual identity, Mr. Sibbal, then how does a court then deny the fact that you are entitled to a recognition of certain other rights which flow out of that sexual
No,
identity?
Malaj, that's for the state to do. This is the problem, Malaj. Your Lordship is now doing something which the state will do in the context of what the state feels is the best interest of the state.
So are you saying, if I may try and
Yes.
decipher, that you don't recognize what is sought, but declare that they have a right to sexual identity?
Yes.
Full stop.
Yes.
The rest is up to the political process.
Yes.
The political process means the democratic process, not
Yes.
really legislation.
Yes. Yes.
There has to be, this thing has to play out.
Correct.
A social awareness,
That's right. Some of them can be, sorry, I'm interrupting.
interaction,
Yes,
like rights are fleshed out, and that's how legislations and laws are made.
correct. And administratively, Manoj, some of these things can be resolved administratively also. So allow it to organically, Manoj, grow instead of an imposition through a declaration. This is my suggestion, Manoj. It's all for your lordships to consider.
Mr. Sibbal, are you suggesting that in the appropriate context of the Solicitor General saying that a committee of
Yes.
presided over by the Chief Cabinet Secretary will look into the administrative issues? So is it your suggestion that if this declaration was to be given by this court, coupled with the administrative aspects which should be dealt with by the committee, and a third aspect would be at times maybe in a request to the legislature to look into enacting a suitable act to deal with this scenario. Is that what you are suggesting?
But it's not the third step. It's not the third step.
No.
Actually, you should allow the administrative committee to look at innovative solutions to deal with the issue. But that will facilitate the process, Malaj. If you don't do that, give that declaration, it won't facilitate that process.
And what is the apprehension of the third? One is not directing a legislature to do it. That's not what is being said.
Well,
I had in mind would be to call upon the legislature to debate this issue.
Malaj, no, I don't think you should do that either, Malaj. It's my request, Malaj. I don't think that in the context of separation of powers, Malaj, that's not what should be done by the court. Malaj, your lordships have not done it before. Your lordships have, what have your lordships done in all these cases, Vishaka and others? I'm sorry. Yeah. So, so what I was saying was, and that is a given, Malaj. Nobody can dispute that fact that they have a separate sexual identity. Nobody can dispute that fact. Even the government has not disputed it. So that's a given, Malaj. You are doing nothing more than what the reality is. Now, whether that has got acceptance or not, at what level it has got acceptance, is something that will be decided, Malaj, in another forum. And to what extent that acceptance, Malaj, is to be translated into a legal framework or an administrative framework. All the other issues, Malaj, Kwesh, Vishakha, and all are procedural guidelines that your Lordship said. Procedural, not legal. Those are procedural guidelines in all of those cases. They are not substantive law. So, Malaj, by and large, I have, Malaj, covered a large area. Kindly look at my note, Malaj, now. Give you enough time so that you... Malaj, just the first part is perspective, which is, what is the perspective with which, sorry, Malaj. Lordship has that?
Yes.
5 Supreme Court judges are being asked to close the debate in Parliament and in the public space through a declaration that same-sex marriages must be accorded the same status as heterosexual marriages. In minorities,
The Supreme Court judges, the Supreme Court.
when I say 5 Supreme Court, it's the Supreme Court, Malaj.
Yeah.
When it's 5
No, we're
distinguished
just sort of clarifying that.
no, Malaj, of course.
Even in a judgment
Without-
of 7-6,
Well,
the decision of
it's
13,
3-2, Malaj,
not a
it's
judgment
Supreme.
of 7.
Obergefell was 5-4. It was the U.S. Supreme Court, Malaj. I know that. I know that. When I said, Malaj, 5, I meant, Malaj, numerically. Yeah. Minorities of all hues, like minority opinions, are protected from institutional discrimination, but they cannot demand as of right that they be accorded a status that should only be bestowed through legislation. That marriage is a heterosexual union granted societal approbation over centuries. It is not a historical coincidence. The premises that support the institution of heterosexual unions is a sociological phenomena which has endured for thousands of years. The essence of the petitioner's claim now is that the state must change its definition of marriage. This is the issue. History teaches us that when a paradigm shift of the law is at stake, the judgment of the court reflects its wisdom and restraint, which is predicated upon its understanding of the consequences of such a paradigm shift. In essence, liberty means freedom from executive intrusion into spaces protected by the Constitution and not entitlement to government benefits. This is the perspective with which, Malaj, I request your Lordships to look at this issue. Then, Malaj, the quick summary of arguments. The Special Marriage Act of 54 is not violative of 14, 15, 19, 21 by virtue of being limited to heterosexual couples, as under 14 and 15, opposite-sex marriages and same-sex marriages represent 2 different classes. This is based on historical evolution of marriage as a social institution and unique dynamics between the partners. The Act is therefore not in violation of 14 and 15. Under 21, there may exist a right to choose one's partner as a function of privacy and dignity. Hence, members of the LGBTQIA+ community are at liberty to choose their partners as per the customs and usages as evolved, if any. However, there is no fundamental right to the legal recognition of such unions by the legislature. As of now, the only recognition that is available in law is in respect of unions between man and woman. The Act is therefore not in violation of 21. Refer to Puttaswamy, the passages, Malas, I don't have to, your lordships are already aware. Then, Malas, I am very strongly opposed to this reliance on foreign judgments, quite frankly. Foreign judgments where same-sex marriages are delivered in the context of the socio-cultural environment of the relevant country and in specific factual contexts. Therefore, they cannot influence the decision-making process in India. However, they provide valuable examples of the following. 1, the necessity of public discourse and engagement with the issue of same-sex marriages. And 2, incremental changes in law and policy on same-sex marriages and concomitant rights. Well, as I've given, Gaidan refers to it. And then Malad's Minister of Home Affairs, Fori, and the Constitutional Court of. In all cases, Malad, there has been huge public discourse, huge. And there are paragraphs after paragraphs that refer to it, Malad. The legal recognition of same-sex marriages is a matter for Parliament to reflect and act upon. The LGBTQIA plus community may be declared as a sexual minority, just as transgender community is recognized for their separate gender identity. This is another aspect that your lordships may explore. It's akin to minorities, which must be, in a secular constitution, must be given protection. So there are two-pronged, Malads, declarations that your lordships can think of. One, their separate sexual identity, and as a sexual minority, protection of the state. They are also a sexual minority, and minorities in a secular state need to be protected. So the protection in a secular state available to minorities generally should also be available to sexual minorities. Persecution.
I would put it in a wider perspective. Minority in a democracy. Every minority in a democracy.
Yes, I agree, Malad. I agree. Yeah. When I said when secular.
We need not.
All right.
Here, there are minorities which are not. You see, there's a certain connotation.
I understand. I appreciate
discrete
that. I was
discrete minority concept.
I agree, Malad. I was only thinking in the other context. Yes, I agree. Broadly. So these are two areas your lordships can think of, Malad, taking it forward. Now, Malad, let's come to the text, purpose, and intention of SMA only contemplates to deal with heterosexual marriages. The court cannot interpret the enactment and declare that the SMA covers same-sex marriages through any process, according to me, misinterpretation. I've written the word interpretation, word recognized by law. It'll be completely misinterpreting the statute. In fact, Malad, one of the questions, and I don't want to waste your lordship's time, was asked, when you refer to person in 4.1, what does it mean? Malad, when you refer to person in 4.1, at that time they are unmarried. So you can't refer to them in any other way. It's as simple as that. I hope I've made myself clear. You couldn't have referred to them as spouse. When you talk of two persons, and what it says is they should not have had a spouse. Otherwise, they can marry.
Yes.
So persons in 4.1 can only mean persons who are unmarried. So to interpolate into that the concept of spouse is wholly alien. You remember that, so I won't take you to the statute, that's all.
Yes.
Then, Malad's declaration of a substantive right to marry and its legal recognition. Petitioner before the court are seeking a declaration that this court confers on same-sex couples the same rights that are available to heterosexual unions. Recognition of same-sex unions can take place in two ways, either through legislation which confers recognition to same-sex and LGBTQIA unions, or through a declaration by the court holding that such unions should be recognized by law. Therefore, the court must consider the following. 1. Does the fundamental right to choose your partner include the right to marry, dehors a legislative enactment recognizing such marriage? 2. If the answer is in the affirmative, then is the state obliged to legislate and recognize same-sex marriages and accordingly confer the same attendant benefits that heterosexual marriages have? Implicit within these two assertions by the petitioners are two assertions by the petitioners. First, that opposite sex and same-sex couples are part of the same class. Well, this is completely conceptually erroneous. Therefore, there can be no discrimination between them under 14 and 15. Second, that a marriage is a union between any two persons irrespective of their gender and sexual orientation. Hence, the right to marry under 21 includes the right to be legally recognized by the state as such. The union between heterosexual couples recognized within society, even in the absence of law, is a sociological phenomenon, the organic evolution of which has endured thousands of years in different forms. And I won't read it further, I'll just show this to your lordships, that what has been happening in Europe and actually in the developed world over the years is there has been a breakup, an atomization of the family. And because of the atomization of the family, problems have arisen. Divorces take place, people start living with each other. And therefore, the need to regulate came to Europe much earlier than it has come here. The atomization of the family has started here because of the process of economic liberalization and people having their own dreams to follow, so to say. So it is this process that needs 1, recognition, 2, needs evaluation, and 3, needs legislation. So first recognize, then you evaluate, then you legislate. You don't have a declaration from the court saying, this is what we decide. So therefore, in paragraph 6 here, of this part, consequently, individuals started exercising choices, such as issues of divorce, custody, maintenance, amongst others, were required to be addressed and regulated. This could only happen through the medium of law. Therefore, for the first time in 55, Parliament enacted the Hindu Marriage Act of 1955. Now, I heard somebody say in the Oxford Union that, we are a vote bank. Tomorrow, the politician will have to run after us because we too have votes. This is the dynamics of society and within society. You should allow that dynamics to play out. You have to allow that dynamics to play out. Then 7 is important from our standpoint. These historical developments in the context of societal and community standards prevailing from time to time demonstrate that heterosexual and same-sex couples were not only perceived as belonging to separate classes, but that the legislature chose not to recognize and regulate heterosexual marriages as distinct from non-heterosexual unions. Therefore, the contention of the petitioners that the court declares same-sex unions and heterosexual unions as belonging to the same class is belied both by history and legislative intent. Because their argument was that this, and your lordships also mentioned, this has been there for centuries in India. So in 1955, when the law was enacted, Parliament knew and chose not to declare them mullahs. That itself gives you, that itself proves the legislative intent that we didn't want to include them here. So both historically and through legislative intent, they don't belong to the same class. They can't. So this whole argument of 14 and 15 is a non sequitur. So then I discussed NALSA, which is gender identity. I don't have to say anything more on that. I've already said what I had to say. Then Puttaswamy, your lordships, I've quoted the paragraph. Your lordships have dealt with NALSA in Puttaswamy. So I've quoted that paragraph. I won't trouble your lordships. Then human dignity, the aspect of human dignity and privacy, the relationship between dignity and privacy is para 13. and then Navteej Johar, which elaborates upon the concept of privacy with reference to an individual's sexual orientation, which is fine. Then privacy in public spaces, para 15 is important. The choice of sexuality is at the core of privacy. But equally, our constitutional jurisprudence must recognize that public assertion of identity founded in sexual orientation is crucial to the exercise of freedoms. So you need to be, nobody can discriminate you if you publicly identify yourself. That also is part of privacy. Then Miller's autonomy and privacy. Autonomy and privacy, para 16, are inextricably linked. Each requires the other for its full realization. Their interrelationship has been recognized in Puttaswamy. Privacy postulates the reservation of a private space for the individual described as the right to be left alone. The concept is founded on the autonomy of the individual. The ability of an individual to make choices lies at the core of the human personality. The notion of privacy enables the individual to assert and control the human element, which is inseparable from the personality of the individual. The inviolable nature of the human personality is manifested in the ability to make decisions on matters intimate in human life. The autonomy of the individual is associated over matters which can be kept private. These are concerns over which there is legitimate expectation of privacy. It has nothing to do, Malaj. See, the moment you cross the boundaries, the contours of privacy, you come into the public space. Within the contours of privacy, you have complete freedom. The moment you go beyond the contour, well, then societal responses, debates, discussions, acceptance. Don't give that absolute right to be recognized. So then, Malaj, sorry.
In the absence of an interfaith marriage law,
Yes.
what you are saying is, in the absence of an interfaith marriage law,
Yes.
which regulates intercaste and interfaith, could you have gone and said that I am not enabled, so make a law? I have a right to marry.
You could have, you marry, Malaj. Nobody will dispute that. Who prevents you from marrying? What you're asking for is not that, Malaj. They are married. The problem is not that, Malaj. You can call it by any name, which is why, Malaj, it's really not necessary for your lordship to say marriage is part of 21 or 14. Marriage is a union of people. It's inalienable. I have a right to be together with anybody I want, maybe same sex, maybe heterosexual, maybe anything. This is the problem. It is the recognition which matters. It's not the union which is a given, Malaj. The heart of the issue is recognition, Malaj. What? Now, Malas, paragraph 19 at page 9. Consequently, both same-sex and opposite-sex marriages are premised on the same human needs of love. This is the argument. Affection, stability, longevity, legislative regime is built around dynamics that are unique to heterosexual marriages. So too, a new legislative regime for same-sex marriages will have to respond to the unique characteristics and challenges that same-sex couples face. That's what's important, Malas. They will face different challenges. Let us assume for a moment that Parliament makes a law only with reference to LGBTQIA plus unions, as it has done for the transgender community. Would such a law be liable to be struck down on the ground that there can be no separate law for same-sex unions because they belong to the same class as heterosexual? I submit that such a law, if made, can never be struck down because different procedures will have to evolve in the unique context of same-sex unions. The consequential issues that are bound to arise when dealing with reference to such unions may not be relevant in the context of heterosexual unions. Therefore, the petitioners' contention that they are being denied equal protection of the law by virtue of them being excluded from the SMA is liable to be rejected. The contention is based on an incorrect assumption. Both society and the law must consider them as belonging to unions of the same class without reference to their sexual orientation. Therefore, the exclusion of SMA is not violative of 14. So this is on the Article 14. Well, that I'm done with that. Now 21. Any form of union between individuals is a matter of choice. Such unions are protected under the right to privacy under 21. This in turn culminates in the right to marry a person of one's choosing. However, it is submitted that beyond the choice of one's partner is the legislative recognition of such choice, which in itself cannot be a fundamental right for the reasons that follow. The petitioners rely on the following.
Just 1 minute.
It is.
It's and then if you
Gets
take it slightly wider
Yeah.
in terms of that concentric circle,
Yeah.
the largest circle, the broadest argument is there is no fundamental right to claim any legislation. You have a fundamental right Negative rights, positive rights.
Negative.
So if they are infringed, you come to court or enforce it.
Right.
But there is no right to claim a legislation or a legislative
That's
regime.
precisely why we have the Constitution.
19 right.
Precisely for that reason. In an orderly society, you need the rules of the game to be played out on certain fundamentals. And that fundamental law is the Constitution.
So you are saying that the
And the
drill down of this whole case is that what is being claimed is a legislation,
Yeah.
a right to.
A legislative recognition of the institution.
That's what is the heart of
Therefore,
it.
your submissions really say, okay, go ahead and get married.
Yeah.
There's no restraining an individual
That's
from
right.
getting married, even if you belong to the
You-
same sex.
Yes.
But
Actually,
you
the
can't really
of-
insist on
Yes.
the
I think
legislature enacting a law.
Short of court recognition.
Yes, exactly.
Actually, the solicitor did say something on that, but you're building on it. And
Yes, yes. We always build millets on the
yes, yes.
on the basis of what. That's what ultimately all science builds on failures, Mullas.
Yeah, these
Yes.
are new territories.
I'm
that
building
we
on
need to
success.
If I am
figure out.
looking ahead, I'm standing on the shoulders
Yes,
of big
yes.
giants, is what he said.
Now, Mullas, para
Bernard
25.
Bernard Shaw said that.
That's right. I was trolled, Mullas, thinking that I'm sitting on this side, Mullas. But I'm assisting the court, I'm on no side. Para 25. The petitioners rely on the following three judgments of this court to
If social acceptability is the test, I'm not sure whether your arguments are socially acceptable to the other side. That's the test.
That's right.
What's recognition is what?
No, we do our best, Mullas, to the best of our ability, and we need to take it forward. We don't need to be anachronistic, Mullas. We must recognize the reality, both in terms of aspirations as well as on the ground.
And ultimately, Mr. Sibbal, the human race always survives on a sense of optimism of a better future.
Always, always,
And
always.
that's what we live on as well as judges.
Absolutely,
Absent that, what are we doing our job for?
That's why we are here, Mullas, as partners in this enterprise. Absolutely.
Everybody becomes.
The petitioners rely on the following three judgments of this court to assert that a right to marry is recognized under the Constitution, which must be extended to same-sex couples. However, I submit that the contours of this right evolved under specific factual. Well, none of this relates to same-sex. You'll also remember in Shafeen Jahan what happened. That young lady.
You can skip that, actually.
Yeah, so we all know that. So, Mullas, then comes to Mullas, very interesting on Puttuswamy. But what your lordships relied upon. The whole.
Mr. Sibbal, you know what happens is when you write, and this is really letting out a bit of a secret, when you write, you're also trying to push the paper as a judge. If you didn't do that, I mean,
That's true. That's true. That is true.
in everything that you write, you're trying to
No, but that's
push the limits, so to speak.
but that's exactly what should be done, Mullas. Ultimately, the law has to evolve in the context of changing times.
And that's what the legal arguments would be also.
Yes.
Take it to a next level.
That's right. Absolutely. So, Mullas, your lordship talks about, sorry. 30, Malaz, what Aristotle said is true even today, Malaz. I just read that quoted by para 30. Greek philosopher Aristotle spoke of a division between the public sphere of political affairs, which he termed as polis, and the personal sphere of human life, termed oikos. This dichotomy may provide an early recognition This dichotomy may provide an early recognition of confidential zone on behalf of the citizen. And then Aristotle's distinction between the public and private realms can be regarded as providing a basis for restricting governmental authority to activities falling within the public realm. On the other hand, activities in the private realm are more appropriately reserved for private reflection, familial relations, and self-determination. I won't read further, Malas. Your Lordship's quotes other things, but this is rather instructive. Para 31, further the court dwelt upon the right to be let alone. Malas, let's leave that. Roscoe Pound, we can leave that. And then, Malas, so para 34, Malas, after I've quoted all this, para 34 at page 13, the right to be let alone or left alone, which necessarily contemplates a negative obligation on the state and on society to not interfere with choices that impact no one other than the person making them. However, where the exercise of the right to privacy has a public dimension, the state may create regulations in the larger interests of the community.
The right to be left alone.
Yes. So it is submitted that the legal recognition of marriage goes beyond the private sphere into the public domain, it being an institution with ramifications for society at large. To hold choice to be the basis of any form of LGBTQI plus union, and their recognition cannot ever be a fundamental right. Societal standards evolved over centuries and have a vital role to play in any exercise of recognition by the state. The state has regulated the parameters of choice within the conspect. There's something wrong with us. There should be a full stop. Within the conspectus of marriage, whether that be in terms of the number of partners, bigamy, polygamy, or in terms of the age of marriage. This regulation is based on societal propensities, which for better or worse, guide the legislature in the choice of its policy. If individual choice or the choice of unions were to be the basis of the grant of legislative status, then any form of union amongst individuals could receive such status. That by law is impermissible because no fundamental right is absolute, and the contours of exercise of each fundamental right are determined by law, but subject to interpretation by the court from time to time in the context of new challenges faced by society as it evolves. Then, Mullahs, I've dealt with Obergefell, and Mullahs, the four principles, I won't read the judgment. Obergefell relied upon four principles, and according to me, completely wrongly. Because the four principles were relied upon in the context of Zablocki, which was payment for parental care before you can marry, which had nothing to do with the right, and loving, which was interracial. And from these two judgments, they extracted the principle that they laid. I just want to...
Which was the first one?
Zablocki.
Zablocki and then loving. Those are the two judgments.
And
And both are irrelevant to the issue.
No, loving would be...
Interracial.
Yes, akin to intercaste.
Because it was heterosexual.
But it was as intensely...
Yes. But Malas, we are in a different, I agree, Malas, but we are in a different sphere altogether.
No, look at social processes. It was as intensely contested.
True.
As intensely,
True.
if I may use the word, shocking or blasphemous.
Absolutely. That is true, Malas. I'm just, Malas, trying to indicate to your lordships, Malas, the issue was not that at all. Then 38, this is important, Malas. Therefore, the submission that the right to marry and its recognition in respect of the LGBTQI A+ unions is embedded in 21 is therefore untenable. While it is true that those who are part of the community are entitled to choose their partners and declare themselves to be by usage or custom to be married, its recognition would still involve legislation through Parliament or the state legislatures, the case may be, since entry 5 is of the concurrent list. It's exactly, Millard's, what my Lord has been, Millard's, debating throughout the day. Therefore, while the right to choose one's partner may be within 21, there exists no unqualified right to legal recognition of such marriage by the state. Then foreign judgments, Millard's, Gaidan I have dealt with. I'm not, your Lordship is aware of it. And I said, this is ultimately, once you give the recognition, that two-pronged recognition that I'm talking about, then the litigation will go the Gaidan way. Then Gaidan I have dealt with. Obergefell, Millards, again. Millards, I just want to read, if your Lordships don't mind, the quotation. Because remember, even in the United States, it was only in 2003 with the judgment in the Massachusetts case, Millards,
Lawrence.
that for the first time it was recognized. That's the Goodrich matter. Now, Millards, I want to just, where is Roberts?
Roberts is gonna.
Huh? Well, just to give me a minute. Well, just come back to page 13 if you don't mind. Well, I'm sorry. Yes.
13.
I just wanted to read Chief Justice Roberts, just a couple of paragraphs, if your Lordships don't mind. Para 37, and just the quotation, Mullahs, if I may read.
Yes.
But this court is not a legislature. Whether same-sex marriage is a good idea should be no concern to us. Under the Constitution, judges have power to say what the law is, not what it should be. People who ratified the Constitution authorized courts to exercise neither force nor will, but merely judgment. Although the policy arguments for extending marriage to same-sex couples may be compelling, the legal arguments requiring such an extension are not. The fundamental right to marry does not include the right to make a state change its definition of marriage, and a state's decision to maintain the meaning of marriage that has persisted in every culture throughout human history can then hardly be called irrational. In short, our Constitution does not enact any one theory of marriage. The people of a state are free to expand marriage to include same-sex couples or to retain historic definition.
Partly Holmes's formulation.
Yes, partly. Right. Now, as I was now I finished Gaidan. I'm not going to trouble your Lordships. You're fully aware of the judgment. Then Obergefell versus Hodges I've done. Fori, Mullahs, Fori also. Yes, in Fori, it's what's important, Mullahs, para 52, if your Lordship don't mind. Page 18, the quoted portion. Has the public had an opportunity to have its say? For the purposes of the present discussion, I assume that the extent to which the public has been consulted would be a relevant factor in determining the appropriate remedy to be ordered. Even making that assumption, the contention by the state and the amici to the effect that the matter is not ripe for determination by this court cannot be sustained. The stark claim that the public has not had an opportunity to engage with the issue is not borne out by the facts. A recent memorandum of SALRC on domestic partnership testifies to prolonged and intensive engagement with the public. The memorandum establishes three things. First, there has been extensive public consultation over a number of years. Secondly, a final SALRC report can be placed before Parliament within a relatively short period. Thirdly, the report can be expected to contain a comprehensive proposal intended to provide appropriate relief, which is in a format quite different from that which the applicants propose. The matter of the relief to which some same-sex couples are entitled would therefore appear to be ready for prompt consideration by Parliament. The orders to be made by this court should be taken account of this fact. This was the extent of consultation, Millards. You look at Obergefell, same thing. Look at Fori, same thing. What we are being told now to your Lordships is Parliament, don't go to Parliament. Parliament will not do any of this. Please, you do it. It is completely inconsistent with what's happened in other jurisdictions. Para 53. It's important to note that the presence of meaningful public engagement is not the same as public consensus. For if it were, the general value of democratic decision-making would override individual rights, which is what my Lord Justice Bhatt said, and it's right. You don't have to have consensus on these issues. This is even more apparent in the judgment of the Constitutional Court of Taiwan, which counts as public engagement over a decade's worth of failed legislative attempts to legalize same-sex marriages. However, that engagement, which manifests as Law Commission reports, bills in the legislature, referendums, high court decisions, state legislations, is absent in India. Therefore, it is apparent that while there are liberal democracies, such as ours, granting legal recognition to same-sex marriages through judicial decisions, such decisions cannot be imported into India without a reference to societal context. So public engagement goes hand in hand with another approach, a form of approach. I know something's wrong here. Countries that have conferred state recognition on same-sex marriages, incrementalism. This necessarily meant steps by the judiciary or the legislature towards the recognition of the rights of same-sex couples, either before or after a declaration of marriage equality. For instance, Mexico City recognized the cohabitation partnership of same-sex couples and their marriage since 2009. At the federal level, Supreme Court of Justice declared as unconstitutional any federal law that considered the purpose of marriage to be procreation. So all that happened. Sodomy, Mullers, South Africa, and Mullers, you had Stachwell relating to pension rights. You had Detroit relating to parental rights of permanent same-sex life, and then Fori recognized the equal right of same-sex couples. So this has been incremental. It always has been incremental. On the other hand, Portugal gave same-sex couples the right to marriage through legislation, but has not yet bestowed the right to adopt. Similarly, the Belgian Parliament in 2003 recognized the right of same-sex couples to be legally married, and later in 2006 granted the right of adoption. So there is no set pattern with respect to the route to legislation of same-sex marriages and a conferral of the attendant rights, depending on the issues of federalism, of the relationship between judiciary and the legislature, and of the synergy amongst law, society, and religion. Countries have taken steps that suit their unique circumstances the best, which is why I say that we should not rely upon these foreign judgments at all. So, Mullahs, then I quote the order in Nalsa. Well, as your lordship is aware of it. But what's important is what I have said in para 61 at page 21. And I'll leave it. Therefore, instead of limiting its judgment to the reliefs prayed for by the petitioners, I submit that this court needs to address the following issues. Whether the LGBTQI plus community, being a sexual minority in a democracy, I changed the word, Mullahs. The lordships may change that for me. In a democracy, is entitled to be protected even in the absence of a law, given that their sexual orientation is different from heterosexual persons. The necessity of procedures which recognizes, without conferring the status of marriage, the impediments that come in the way of the LGBT unions. 3, the necessity of administrative procedures, as the government has suggested, and guidelines recognizing that sexual orientation is a physiological phenomenon and the same-sex unions involve intimacy outside the heterosexual world, and that such unions cannot be discriminated against. The above is possible only when the LGBT community is recognized as a sexual minority in tandem with the recognition of transgenders having a separate and unique gender identity, which now has been recognized by law. Once The above is possible only when the LGBT community is recognized as a sexual minority in tandem with the recognition of transgenders having a separate and unique gender identity, which now has been recognized by law. Once the court, through a declaration, recognized the community as a sexual minority having a separate and unique sexual identity, then issues with reference to civil rights, such as adoption, gratuity, surrogacy, can be addressed by government through stratagems which may involve administrative solutions, both within the government and the public sector. Till Parliament addresses the issue of legislation, the government can, through executive actions, consider the recognition of certain rights which are necessary in the fulfillment of the aspirations of the LGBT community. Then, Malaz, the next part of it, I don't want to deal with because it deals with the Special Marriage Act. I don't think that's necessary, Malaz. All that I say at the end is, in a way, this moment should be celebrated, that your lordships are at least dealing with the reality of the situation. But that celebration must not result in an overreach, though it must recognize the reality and set systems in place for the state to move forward. But without moving forward, Millets, many of these people will be discriminated against. How that is to be done, in what manner it is to be done, Millets, I think that the government can ponder over it. But as for me, Millets, I think that what they've asked for is not a fundamental right. What they must get is something short of it, but something that's meaningful. Thank you very much.